CISO Legal Risks and Liabilities.
Thank you very much. Thank you all for coming. We have had a lot of discussions before this panel about how to manage it. And people here are professionals. I came in wearing a hoodie. So the discussions were interesting to say the least. But my take on panels, and I'll make this very quick, is that they tend to be all about introductions. Then you have a lot of people trying to seek consensus. And I find that quite boring. Now, I don't think any of us will disagree on much, but I would like to at least make the attempt to make this panel fun. So how about you all make fun of me, not anybody here, while we go through this? Because I did get some permission, limited permission, to cut people off to try and make this happen. So just boo or something as we go through this.
Oh my God.
And with that, we're going to talk about CISO legal risks and liabilities, but first, the very quick introduction, starting with Kirsten.
Hi, everybody. Thanks for joining us today. Kirsten Davies. I'm the Chief Information Security Officer for Unilever. And relevant to this topic, I've lived and worked on 4 continents, sometimes with local contracts. We're going to get into that.
All right, and I am Stuart Baker. I worked in the government at both NSA and DHS. I used to say I'm the child of a broken marriage. I do the Cyber Law podcast for those of you who have listened to that.
So he's the lawyer in the group. I am most definitely not the lawyer in the group.
That's an applause line.
Alyssa Miller, I'm the Chief Information Security Officer for Epic Global. My background stems a lot of global financial services organizations, and now I find myself, while working in the legal space, again, not a lawyer, so please don't take anything I say as legal advice, but really appreciate y'all being here today. This looks like a really wonderful group.
Let's repeat that. Not lawyers, not legal advice, just in case, right? Kirsten, we agree on that?
Not a lawyer.
Not a lawyer. So getting started, before we dive in, and we want to go through a lot of things, one thing brought us here. One thing only. We don't want to touch on that topic too specifically, but it did start the whole, I guess, hype on the topic, reality of the topic. Joe Sullivan and what happened with Uber. So Stuart, why don't you're a lawyer, so I'll say this shortly. Take us through that.
And you know, I've met with Joe since I got here. So and he's a friend, and I respect him a lot. He screwed up for sure. It was an aggressive attempt. He'd gotten what amounted to an extortion letter from people who had seized information about both customers and drivers. They said, we have the information, and we think you should pay us a lot of money. It was $100,000. They thought it was a lot of money. That was way beyond anything that Uber had ever paid for bug bounties. But it was a fraught time. The FTC was just finishing up a second investigation of breaches, and having a third breach would have been a disaster. And so the question was, can we keep this a secret? And by treating it as a bug bounty, they could say, well, this is lawful, and we can pay for it, and we can get them to sign an NDA. That was very aggressive lawyering. He was not Uber's lawyer, but he'd been deputy general counsel, and this was part of the problem. He was really very well regarded by the lawyers at Uber. And they started down the road of, let's make this a bug bounty and stretch the program so that we can fit these guys in it. And then he asked for an NDA and a promise that the data had been destroyed, not accessed, which turned out not to be true. And it seemed pretty clear that people at Uber knew it wasn't true when they asked for an assurance that it had been destroyed. All of those things might or might not have produced a criminal indictment, but it was a perfect storm for him. And CISOs know there is politics in any company. The politics at Uber were just ugly as can be. Travis Kalanick had left, and it was all about, we got to punish bro culture, we got to end it. They brought in a completely new set of Obama administration veterans to clean the company up. And when they found this mess, the decision by the new management was, let's hang Joe Sullivan out to dry. Let's make it all about his mistakes, and maybe the government will go easy on us as the new guys. So that's how we ended up in this situation where he was cast as the bad guy, and so a prosecution by all his old colleagues who probably watched with some degree of jealousy when he made a bunch of money at Uber, decided we have to teach him a lesson.
Thank you very much. I wonder why you stopped there. So this is the background, and thank you, Stuart. I would like us to just remember for a second, now that we have that background, that we are here because CISOs now are facing repercussions. Many in the crowd, if you're a CISO, thought about, should I leave this occupation? Should I still be a CISO in the future? What does this mean for me? And with Joe's case specifically, why is the CSO in this case the only one standing trial? What's going on here? What does this mean for our industry? Where is this going? And I would like to just quickly go around the table, well, the chairs thingy here, and see what is just jumping at you. Whether it's about executives, whether it's about who we used to be, whether it's about how we should handle ourselves. From all that trial, from the past year, what jumps at you? Let's start with Kirsten.
It's a shifting landscape. I think that's the biggest thing that jumps out at me. So for those of us who are involved in multinationals, perhaps multi-regional categories of conducting cybersecurity, we already know that the fog of war is difficult when you're in the middle of an incident and you've got data coming at you from all places and corporate comms and legal and HR and then the execs and your team and everybody just coming at you at all times when you're trying to deal with this incident. Now we have a shifting landscape of regulatory requirements with regards to, if you're in India, if you're in GDPR, Europe territory, if you're in the US, and the SEC rules that are coming out. Now it's just this constant shifting sand that we're trying to balance ourselves and balance our teams on and balance the incident response on. I think that this just brought a whole new focus of lens around the typical, what we would call CYA maneuvers, right? Are you documenting? Do you really have a published and polished playbook? Are you following the playbook that you have? Because after these things happen, even though you're in the midst of the fog of war, there still is the opportunity for investigators to come back, depending upon what jurisdiction you're in, to check your protocol, to check your process. Did you follow the playbook? Was your playbook thorough? Did you do what you were supposed to do? Did you inform law enforcement at the right time? Did you inform them at all? Did you talk to the authorities? Did you talk to your insurance company? Did you talk to the privacy regulators? It's shifting sand, shifting sand.
I would like to go to Elisa.
Yeah, so I mean, the way I look at this, first of all, is for every CISO in the room or any aspiring CISO in the room, stop panicking. All right? After this whole case started, everybody was like, oh my God, they're holding him liable for the fact that they had a breach. No, they're not. That is not what happened. You just heard it described by Stuart. The very first words out of Stuart's mouth were, he screwed up. Okay? The fact of the matter is, it was an obstruction of justice charge, and I can't think of the term.
Misprision.
That's it. I don't know what that's a new one on me.
I don't think justice knows what that is.
Right, exactly. but so, I mean, the focus there was a little bit different, right? It wasn't like he was being personally held responsible because they got breached. Now, the other thing that Stuart said that really caught my ear, which when you talk about the fog of war, and we're stuck in that moment, and we're being bombarded from all sides. When you find yourself asking the question, how can we keep this a secret?
It might
Right
not be
then and there should be your indication to yourself that maybe that's not the road I want to go. Because when we think about all of these regulations, more that are being created every day, you've brought up some of them internationally that we deal with, the focus there is on the open communication of these situations. If you listen to what the FBI has to say, they're upset because he didn't report it to them, and they feel like they missed the opportunity to catch one of the actors who has never been caught and who did expose the data despite all the efforts to try to prevent that. Right or wrong, I've seen the arguments both ways on that. But that's the reality, is if we think about this in terms of, what actually was being charged here and what the actions were, we don't need to panic. This doesn't call bug bounties into, question, that was another thing that people brought up. I mean, I think, Stuart, you did a great job of describing, I think you called it stretching it, right? I mean, they really stretched the limits of what a bug bounty is meant to be. So if we think about that, we stick to what our playbooks are, those processes, those programs we've put in place, be true to those. I don't think that this is a case where we have to panic as CISOs like this is some, epic new shift in our liability as executives in our organizations.
I mostly agree with that, although I think part of the lesson here is, when they put that O in your title, you didn't think that was for free, did you? You now have executive responsibilities. If I could give one piece of advice about this, I completely agree. This was a perfect storm, and it's not likely to happen again. Usually, companies can only violate the criminal law through their employees. So if one of their employees violates a criminal law, the company's going to go down too, or maybe alone. This was an unusual circumstance that they were able to say, oh no, we're the good guys, we're a new company. But the key here is, if you stay in your lane, you're most likely not going to end up as the person who takes the fall for something that was done wrong. If there was an organizational problem in the Sullivan case, it was that he had a lot of roles, some of them informal and some of them formal, so that there were lawyers involved in this, but they looked to him as a leader and let him set the tone and set the strategy. The CISO's job is not to lawyer breaches, it's to remediate them, it's to respond to them. And as long as you're listening to your lawyers and making them give you advice on these things, it's very, very unlikely you'll find yourself in a Sullivan-type situation.
So I would like to quickly go through several things we can start deep diving into here, just by what people said so far, and then pick up the pace. Number one, this was a unique case. He was the Deputy General Counsel. Quickly, not legal advice, do not take on the Deputy General Counsel role if you're the CISO, okay? Done, you got something out of this funnel. Number two is, don't break the law. Now, it sounds stupid, but honestly, when this all started, and I went to talk to lawyers, right, they all said, don't break the law. I said, I want more. And three, which everybody touched on, is how do we build the right processes? Elevation, escalation, how do we create a joint responsibility? So I want to start with something Stuart just said and move over to Kirsten, if you wouldn't mind, which is, what is the CISO? Who are we now? How is this all affected?
Well, you made a really interesting point, right? Which is stay in your lane. I'm sorry, what is my lane as the CISO? my lane is about a 10-lane highway going in 15 different directions at any given time, right? Which I think that's the challenge that we have. If we all had a similar consolidated one way of looking at the CISO role, this might be a little bit easier of a conversation, but it's very complex. So some CISOs in the room are very focused on the IT footprint of your organization, and that's what your job is. You're there to do that. Some CISOs in the room are also, by the way, this is the elevation of the CISO role, right? We've been on a journey for quite some time. Some CISOs in the room, you have BISOs, you've got business engagement officers, you're running product security, not just IT security. You're responsible for the security of the services your company provides. Some CISOs in the room are straight up risk executives, and you may not even have an operational arm in what you're doing, or you also have an operational arm, but you're overseeing the risk posture of your organization. So exactly what lane are we in here, sir? Right.
I didn't hear lawyer.
No, but I think what's super interesting around this is I think some of us still have a few scars on our backs from colleagues who've lost their jobs due to a cyber incident that was actually not their fault. It was somebody else not doing what they were supposed to do, but the company had to offer up, a proverbial head on a platter. I think what's super important is to understand our primary role is to evangelize the risk, the cyber risk posture of the organization. Our primary role is to make sure we are dispersing that message. We're evangelizing that message. Yes, we want to influence change. Yes, some of the things we can change ourselves. But at the end of the day, we have to be having those conversations. You can't have a conversation with yourself as a CISO and say, wow, should I incident respond this way? Yes, you should. Wow, should I do this? Yes, you should. You need to talk to your business executives. You need to engage legal and HR and finance and your execs, your leadership executives. Sometimes the board, you've got to go to the board and say, we're sitting in a situation here, right? That's not a popular stance to take, by the way, as a CISO, right? So I think understanding that your lane has shifted whilst you have been doing your job. Was that a good use of the term whilst?
Yeah, that was
Well
great.
done.
I work for
Well
a British
done.
organization. That's what's important to realize. We are risk executives. We're not just tinkerers. We're not just operators. We're not just IT security. We are risk executives for the organization, and it's our job to make sure that as that lane is shifting, we're moving and shifting with it.
So let's talk about that lane a little bit, because when you said it, and you actually said something earlier too that made me kind of respond to it, is like, there's a lot of us out there, myself included, who are out speaking to other CISOs. We're offering advice, and we're saying, we need to understand the business. We need to be more a part of the business. That's kind of an evolving. That's another area of the CISO role that's very much evolving. We traditionally, I think, styled ourselves as technologists, as an oversight role. It's becoming more and more that I'm hearing CISOs talking about something that is honestly music to my ears, right? We're there to empower the business. We're there to, make the business better. Put it in 100 different words. But let's talk about what the edge of that lane is, right? You're not there to make the business decisions. You wouldn't do that in other cases. So in a situation like this where, this is going to get public and the FTC might be upset or we're going to lose investors or something, that's the business side of it. That's not on us as executives in the space that we fall to be making those decisions. We need to be educating on the risk. We need to be evangelizing it, to use your word. That this is the situation. This is what's going on. This is where we're at. We are being extorted actively as an organization. We have this problem. We don't know if I pay them $100,000 if they're going to be true to their word or not. And we have this whole situation that's just occurred with the FTC. Could be a very different conversation if you bring that open. Now, I wasn't in the middle of Uber. I don't know how much. I know one side says this was all clearly communicated. The other side says, no, we didn't know anything because we don't want to go to jail too. And, so there is that piece. But at the end of the day, that's where, you are not, your corporate lawyers are not your lawyers. Remember that too, right? So at the end of the day, you have to be operating in the capacity that you are as a cybersecurity professional, as a risk executive, and communicating to those folks who that isn't their primary role, and bringing that context, but make them make those decisions, because at the end of the day, you don't have that legal cover from them. And if you take those decisions upon yourself, you're in a very different world.
So I'd like to use the opportunity to quickly go into how can you protect yourself? That's a nice way of putting it, right?
Yeah.
I would like, by a show of hands, who here is a CISO right now? Okay, now keep your hands up for a minute just for me. Play with me, I know it's annoying. How many of those of you who have a contract, leave your hand up. Those of you who are still in the US and have a contract, leave your hand up. Okay, we have how many people in the room? One? Two? Am I missing anybody? So you go into a room, even with 200 CISOs, and maybe one or two will have a contract. Some of them will have an employment agreement, which you pointed out to me, right? Some of them will have an offer letter. But a lot of the conversation right now, protecting yourself, is, am I an officer of the company? Do I have a D&O insurance? When is that activated? When I'm being accused of something? When I'm not? And then, of course, the discussion that we kind of took the direction with, which I am happy with, is what kind of processes can I put in place so I do my job right? If you go to any CISO out there who survived this, often they have been audited out the wazoo. And they have done their processes right. And they stayed in their jobs often. Unless, of course, this is something for Kirsten to say in a second, right?
Unless, of course, you move a lot. Kirsten, would you like to talk about that?
So, no, I meant, I didn't want to be the one to say unless you're a woman and you don't recover.
Oh
from
my
that.
goodness.
But let's not go
Yeah,
there.
well, we
It's
could
important
go
to
there,
note
but,
in
yeah.
any conversation when something like that happens.
Yeah.
So I would like to kind of go to Stuart and understanding we don't have contracts right now, and yet we are having a contractual conversation, which is the important move on the future. How can CISOs protect themselves?
So, yeah, and there's a very good chance you're not covered by the D&O insurance. You really have to know, you have to see it before you can be sure you're covered. Because just because you're called an officer doesn't mean they said that in the bylaws or to the insurer. So the argument I would make to the management of the company is you need to cover me, given the risks we're talking about, and there's others, right? There's the securities, CISOs get named in securities fraud cases now for obvious reasons. People ask CISOs, how good is your company's security? And very few of them say it sucks. Right? They say, we're really working hard, we're doing a great job, we're among the most secure in the business. Stuff like that, it gets said all the time. And then if it turns out there's a breach, the people who bring shareholder derivative lawsuits say that that was a misrepresentation and that the CISO was kind of the chief misrepresenter. Now, they're still suing the company, but they might throw the CISO's name in as well. And so you want the CISO to be able to do their job without asking, oh, am I going to get sued over this along with the company? Another example that I was going to ask about is there are places where you're in your lane and it's still kind of a legally fraught call, like we're 72 hours into the breach. How many records have been compromised? We've all gotten that question if we've been through a breach. And the answer is never, yeah, I know exactly after 3 days. But if you guess low, there's going to be a claim that there was a misrepresentation and that was designed to defraud investors or otherwise lowball the government response. If you guess high, the company is going to look bad right away. The company does not want you saying, let me see, if I guess low, I'm on the hook for the lawsuit. If I guess high and I'm wrong, the company looks bad, but I come out of it clean, at least as far as liability. The company wants you to incorporate the views of the company and to say, not I'm guessing high to protect myself or low to protect the company, but to say, what's your best guess with legal advice? And the best way to do that is for you to make sure, for the company to make sure, that they have provided a way, an indemnity or an insurance policy that protects you if you act on behalf of the company within your responsibilities.
Or how about we don't guess?
Go ahead.
How about we just don't guess?
That's
Right? Let's not guess and make statements to the press or to a regulator, right? Don't guess. If you don't know, you don't know. Don't say something that you don't know.
Would you mind also expanding on the issue of the word breach?
Well, yeah, absolutely. So that's one of my bugbears.
No.
Yeah. Well, I mean, it's we have events all the time. We manage all kinds of events, right? Teams manage events all the time. Then there's issues that we want to take a look at. Then there's actual incidents, and then up the chain it goes. An incident, maybe there's a named incident. Maybe you have a code name internal to your company where you're dealing with a named incident. You read a few people into the playbook, et cetera, and then a breach is an actual legal term that should not be being used unless your law department, your legal representative has said, this meets the threshold expectation legal definition of a breach. Please stop using the term breach. Please stop using it. The reason is, if it's a breach and you're at GDPR, we might move to the European discussion. If it's an actual breach, then there are regulatory requirements in certain jurisdictions for timeliness of notification, et cetera, to not only the regulators, to your consumers, your customers, whoever you're. So let's be super clear on what this is and what it's not. If I can just build quickly on something you said, one of the things that I think that we need to be careful about as CISOs with our organizations, and we talked about this at the Executive Security Action Forum, and thank you RSA for putting that on every year. It's great. So there's about 200 CISOs that get to go to that, which is wonderful, and I wanted to share some of the information from there without accrediting people. One of the things we talked about was this very thing. Avoid puffery statements on your corporate websites and in any of your marketing. So we do world-class security because guess what? If and when there is an actual incident named incident breach, whatever that is, those shareholders can come right back and take a look at everything that was published, and by the way, they will. As a CISO, if you're on stage and you're in the public and you do a podcast and you do it, well, we have the best security I've ever seen. Guess what? Any of us can fall prey to a successful incident at any time. Just be super careful around the puffery statements. Like, we aim for great security. That's a great statement to make. We have world-class security? Ooh, really? Besides the fact that makes you a target to all those hackers. We love you. By the way, we love you. It makes you a target to all the hackers who want to prove that you don't have best-in-class security.
So this conversation is going in good directions, but I want to stop us for a minute and go back. Stuart, I'm not happy with you.
No, great.
That's okay, we aren't
That's
either.
why I came.
I would like, this happens a lot when we talk to lawyers, especially people who, like you, know a lot, where you refuse to tell us exactly what we need to know. So you mentioned a little bit about DNO, you mentioned a little bit about liabilities. I would like to have 25, no, 3 is fine, pieces of advice for a CISO going into a job and a CISO in the job. I can count them if you like with my fingers, but seriously, if you could help us out with specific advice, that would be amazing.
Yeah, you should have a contract, right?
I'll stop you then. I just asked you a question. I'm stopping you already. What's going on here? Most CISOs in the US do not have a contract.
People in the audience don't have a contract.
If you don't have a contract, then you need an understanding in writing about how you're protected.
All right, so that's number one.
Are you covered by DNO or some other insurance policy? To my mind, that's crucial. And you need, we talked about lanes a little, you do need an understanding about what the lane is. But my experience is that most lawyers are happy to say that their lane is really big. So, and you should probably be happy with that too. You're going to find, at least in my experience, when we do tabletop exercises, as well as when we do real incidents, the lawyers end up having much of the decision-making rolling down to their end of the table because there's always a legal element to it. And so making it clear that you're going to consult the lawyer, and the lawyer is going to make the decision. We talked about calling breaches. I completely agree with you on that. I always thought that the best model was the cardiac surgeons who, after they've worked and worked and worked on the patient, stand up and say, okay, I'm calling it, it's 1:43, and it's a breach. Then you know that that's the start of your 72 hours or whatever it is. And again, the lawyer should be doing that. That's, your understanding is who's going to be making the final calls on this, and some kind of protection. Indemnity is another possibility. There's a lot of things, and you heard me make the argument. This is an argument your company should listen to. You do not want me to ever ask, should I do something that protects myself rather than the company? I should be acting in the company's interest, and I should know that the company has my back.
So I want to grab something you kind of might get lost in the wash there. You mentioned tabletops. And I know for some of us that we take that for granted that those happen. But what I'm discovering is there's a lot of organizations, and I'll actually ask the room, how many of you CISOs out there actually do executive tabletops that are focused on crisis comms?
And I'll quickly add to
Maybe
that, how many of you had your lawyer in the room?
Personal lawyer?
No.
Oh, no,
Yeah,
no, definitely
that's
not.
That's a big difference.
That's a big
Legal
challenge.
team versus personal lawyer.
Because that goes back to what I was
Go
saying
ahead.
before. Your corporate lawyers are not your lawyers. So
That's right.
remember that.
That's right.
But that whole concept, if I think about, and I know we didn't want to really dwell on this situation, but the Joe Sullivan situation, a lot of that was, at least the sense I get, and especially from the way you described it, is he's sitting, he's got this panic, he's kind of worried about his job, he's worried about losing his job, he's worried about what's going to go on when the FTC gets a hold of this, whatever. When you've actually sat down and you've put exactly these types of scenarios, now maybe you couldn't predict this exact one, but when you sit down in an executive tabletop exercise, and you don't focus on the technical capabilities, that happens elsewhere, but you design those tabletops with intentionally difficult decisions like Mr. Sullivan faced, and lay that out. That is a great way to do two things. One, it clearly sets those swim lanes, but two, it sets their expectations so that you know now that they understand this is how this functions, this is how we make these ethical decisions, these are the types of scary decisions we're going to have to make. They're not going to be easy, and they are going to be shifting throughout the course of the event. Yeah, right now we may just have one person who has contacted us that they have some data. This is actually an exact tabletop exercise we did in November, which is why this works out really nice as a case study for this, because walking that through and the aha moments, and the value in the tabletop isn't, of course, the outcome, it's the conversations you're spurring throughout that process. So I would encourage those of you that aren't doing those today, maybe even take this situation as a motivator, but to bring that type of tabletop exercise and to really spend some time designing it. We worked through our compliance team, and they actually were the ones that put this together. Because, of course, you don't want to tell the executives before you get the whole ELT sat down and say, here's the thing. You don't want them to know what's going on. You lose a lot of that, a lot of the value that you get out of them having to think on their feet. But, when it comes to practical advice, that's probably the biggest thing I can put out there for you, is make that a part of it. Because most of us probably do the incident response tabletops. It's that crisis comms and how do we handle all of that piece, investor relations, everything else, that, as was demonstrated here, I think we had, maybe 40% of them that raised their hands? That means there's 60% that aren't doing this today. Yeah. So something to really think about that will really, I think, put you in a better position, that you're not going to feel the same pressures to maybe do things that, are that question of how do I keep this secret?
And just a very short intervention. When you're done, go back and revise the manual based on the lessons that you learned. You've probably got the pen if you've done this right, and this allows you to define your lane in a way that you're comfortable with.
And if I can take a step back too, before you ever even take a job, how many of you have personal lawyers? A personal lawyer? Yeah. So, recommendation number one, if you are a CISO or if you're wanting to be a CISO, find a lawyer. Find a lawyer that you can trust, that specializes in contract agreements, preferably somebody that has worked on the other side of the fence for corporate before, that knows the ins and outs of trying to get somebody out of their contract. Find a lawyer, use someone to help you negotiate your next job. If it's a contract, or if it's an employment agreement, or if it's just a letter, an offer of agreement. Because the only time, barring, I'll come back to it, not the only time. See, I'm not going to make these magnanimous statements. The primary time that you have to negotiate what your relationship is going to be like is before you start that job. So you're going to need exit clauses for good faith. Not just, they're going to want exit clauses for exiting you for cause. You need to have an exit clause for good cause that says you've done everything that you need to do, but you no longer have budget. You get reorged as the CISO and no longer report where you originally negotiated. The company decides to do a massive divestiture or whatever, and then there's a change in your scope as a CISO. You need exit clauses for good faith, because a lot of us, and you know, our tenure is, what is it, 18 to 30 months now is the average for a CISO. Why is that? Because we lose budget, we get reorged, the company decides to stop funding security or just like, fund at a very low level. Whatever those things are, you as a risk executive need to protect your own risk position in the field of cybersecurity outside of your own company. The other time that you can do these things also, and I've seen a lot of CISOs doing this now as a result of these cases upon which I'm not officially commenting, is for you to have the ability to go to your boss, right, your hiring manager, go to the general counsel, go and have these discussions around these court cases, around the big incidents that are happening, some of which are breaches, some of which are being called breaches and they're not, et cetera, et cetera. Use those as an opportunity to talk again about your employment agreement or the letter on which you came. If you've been at a company for a long time, you probably need to revisit that and have those conversations to say, what if this happens? A very dear friend of mine who's a CISO at a major corp, she's just moved to another organization, even by saying she, there's so few of us. I'm like, I'm not gonna tell you who it was. But she actually had a very candid discussion with the CFO of the organization to say, I know you are going to need a head on a platter in the event of an incident to show to the shareholders. That means I'm gonna let it be me, and this is what it's gonna cost you. It's gonna cost you a super vesting of all my equity. It's gonna cost you a year in severance, a year in benefits. Whatever those things are that you need as an individual to give you that little bit of a safety net to say, I am all in with this company. I am here to protect the company, and you need to protect me as an executive. I can guarantee you, CFOs, CEOs, chief legals, they have those in their contracts. I can guarantee you they do. Off soapbox, mic drop.
So this is a good opportunity to say that we work this a lot. The people here on this stage, some others, as the CISO community. I'm specifically working this from teammates, so we've made 3 documents happen. One of them is, I don't have it with me to show you, unfortunately, but CISO legal risks and liabilities is one of them. Oh, you have it here.
It's
Awesome.
right there.
There you go. Where we set immediately after the Joe Sullivan. Tom is going to show it around. There you go.
There you go.
Tom is modeling it for us. Thank you, Tom. CISO legal risks and liabilities, where we went through these 3 steps of how do I protect myself? How do I protect the company? How do I build the right processes and put them in place in order to do things? The second one is, we just did this last week. 80 CISOs wrote this, another 100 reviewed. Thank you, Alyssa, for helping with that, by the way.
Sure.
Generative AI and ChatGPT enterprise risks. Everybody's panicking. Everybody's saying, what about the risks? What do we do now? It's kind of like the internet. It's kind of like cloud, iPhone, smartphones, social media. Everybody's using it. We need to secure it. We need to enable the business. But a lot of scary words out there. So we sat down and wrote this document to look at the risks and look at how do we develop a policy around it if we even need to. We do, but a lot of it fits in our older policy. And third, Microsoft has responded, Google has responded. We wanted as a CISO community to respond to CIRCIA from DHS. 72 hours, what does that mean when we need to report these things? Are they going to give us anything back? Are they going to report what we say to another agency? What is it we actually need to report? How do we handle it internally? They wanted to engage with CISOs. Now they're going to engage with legal, as it's now regulation. A lot of discussion around it. So these are 3 papers you can pursue at your own, time. And with that, I would like to say there is just quickly much more to discuss. Indemnification, which was raised for a second, E&O policies. You're having the discussion about being an officer isn't always easy. Should you even have that seat at the table as an officer of the company? A lot of discussions, but with a lot of disclaimers around the stage here. I'll let Kirsten do the disclaimer first. I would really like us to touch on AI for a specific reason, and Alyssa will start us off on that, but would you mind giving us the disclaimer on why we're touching AI and why we're doing it very shortly?
No.
Okay, so the reason we're doing that, which Kirsten kind of likes to say, is, come on, Kirsten, help me out. Why are we not discussing only AI on this panel?
Only what? Sorry.
Only AI. Why? There was a statement made that, but I believe by you, so I'm going to quote you. If it was Elisa, I will apologize.
Are you just putting people's
I am.
words in other people's
I know,
mouths?
Yes,
it's
I
like
am.
putting words in
Yes,
my
I am.
mouth.
Exactly. Thank you for noticing.
The opposite of Chatham House.
Exactly. Now we have energy in the room. So what I would like to say,
Are you on an acid trip right now?
I would like to be. I never tried. How is this a fringe issue, right? And I'll tell you in a second who said it to me. How is a fringe issue like AI how has it become the core of our discussion? But with that, we don't want to talk about AI forever. We don't want to take over RSA with AI, although that might have already happened. I'm not sure.
I think it's already
Yeah,
happening.
it's-
Yeah, okay.
Definitely
That
happened.
ship has sailed. But we do have something to say about it. So, Elisa, would you mind leading us in?
Yeah, I mean, so where this conversation came from, yes, obviously, oh my God, everything here now is chat, GPT, generative AI, language models, oh my God. So AI, there it's out. No, where it comes into play for the CISO right now is that in a lot of organizations, AI is kind of de facto falling in our lap because it's got connections to privacy, it's got connections definitely to security. We've seen ChatGPT already get breached. We've seen, Samsung developers expose stacks of IP via ChatGPT. All of these things are things that they're coming back to the CISO and saying, how do we secure this, right? So, and by the same token, you've got your business lines, of course, are like, oh my God, this is revolutionizing our industry. If we don't get there first, we're going to be behind. We're going to be, and so all of these pressures are falling to the CISO. And right or wrong, we've kind of been the ones that have had to embrace it. And what we're seeing right now that's going to be of importance from a legal perspective for CISOs and for their companies is the legislation that was already kind of in flight. Especially in the EU, where they were, okay, how long ago did deepfakes come on the scene? But that was the legislation they were working on, and they're in the midst of this, and they propose it, and suddenly ChatGPT drops, right? And so they've now spun that whole conversation to include in their list of general purpose AI systems, which is an important term to know if you're doing business in the EU now. That though ChatGPT and all of these open AI and language model items, they're all falling within those high-risk categories of those general purpose systems. So where this is now kind of falling in our lap is it's something that we have to be aware of, certainly from the security side. And you've got the document up there, and you'll see some comments in there about kind of a multifaceted approach of well, we talk about people, process, technology, right? So it's your policies, your awareness campaigns, and your standard architectures. But from the legality side, there's going to be more of that coming. I know, having worked in the financial space, we saw this from the SEC when we were talking about, words like explainability, which if you don't know what that word is, get really, really familiar with that. Because being able to explain why the chatbot in Snapchat is gaslighting the people that it's talking to, a recent example. Those are the things that are going to come back as we start to make business decisions, we start to make market decisions, we start to make insurance decisions based on these models. Those are things that your business lines might be thinking about, they might not, but when push comes to shove, they're going to come back to you and say, why didn't you tell us about this? So from a legal perspective, that's where that comes into play. In my opinion, it's not really fair. It's not really a CISO's job. This is a much broader compliance and business discussion. But right now, what we're seeing in the market, hence the reason it's been the conversation everywhere here, is that the CISOs are the ones that are right now starting to realize, okay, this is a pretty big deal. We got to do something. And everybody's kind of turning to us as the somewhere between risk and technology people to say, this is how this stuff works, these are the threats, this is how we respond to it, here's how we adopt it safely. So, that's, I think, I don't know, unless you guys want to add something, but we did want to bring that in there because that is the legal implication right now, is that those are going to be laws that we are going to have to comply with at a business level. I have not, thankfully, seen anything that establishes criminal liability for the CISO, thankfully, which is, again, and that I think is kind of that line right there, going all the way back to the beginning, is where I say don't panic, right? It's legal issues, criminal case versus, a compliance situation or a regulatory situation, very, very different in terms of who ultimately gets the end of that particular spear. So I mean, from an AI perspective, that's kind of where we're sitting, and that was a lot of the conversation we had around that.
So yeah, look, there are legal risks here, and they're real. The CISO should not be identifying them. As you say, your compliance people and your lawyers should be doing that analysis. There are existing regulatory and legal regimes that people are already getting ready to apply, especially if they can show that there is a disparate impact on some protected class from the use of AI. This is pre-ChatGPT, but a lot of the tools you're going to be using are AI, but not necessarily GPT. In any event, even if they are, they're going to have a disparate impact. If they're any good, they're going to distinguish between people. And you've got to, somebody, it's not necessary, it's really not a CISO job. Somebody has to ask the question, is this going to have an impact on employment that could result in lawsuits, on loans that could result in lawsuits? The regulators of lenders, the regulators of employers, especially in this administration, are eager to impose restrictions on the use of AI in those contexts if it has any discriminatory impact at all. So, as an example of how bad it can get and how fast it can get bad, take a look at what has happened to facial recognition, which is an AI technology, and has been relentlessly rendered toxic by a bunch of civil society groups claiming that it's racially biased. And 10 years ago, with the technology that they were using, you could say, yeah, that's probably true, that it's not as good at darker faces as it is with lighter faces. Today, that's much less true, but Illinois has passed a law that says anybody who's using biometrics, including facial recognition, if they haven't gone through several steps of getting the consent of the people who did it and explaining to them what's happening to their data, they're going to pay $5,000 per event. And already companies are paying close to $1 billion in damages for using what amounts to AI in a context where they just didn't follow through on some pretty simple legal requirements. So yeah, this is going to be, this technology is going to be rendered toxic, and they're going to sue you over it.
I'm going to do a slight build. Hang on, slight build. But you can ask people if they have questions, and you can come up to the microphone if you have questions. Slight build.
Yeah, so that's what I wanted to say. Please, if you have questions, start coming to the front, because we don't have a lot of time, and we would like to discuss with you. And with that, please, Kirsten,
Is that like
continue.
5 more minutes? If your security is dependent upon voice recognition or facial recognition, there is likely to be a tertiary impact or a downstream impact from AI models. So one of my colleagues decided to try it out, figure out how to do a voice generation. He was able to actually hack into his own banking app using an AI generation of his voice, a voice that he found of him doing a speaking engagement somewhere. So I would say that's probably a bigger focus. I mean, I love what you've said across this, because we do need to be aware and read up on these things. I think the downstream impact is also super important for us as CISOs and operators, is to say, oh, fill in the swear word. If my security defenses are dependent upon something that's now penetratable by AI, you might want to kind of start rethinking your security defenses.
Thank you very much. Dom Segola, Archipelago. You spoke a little bit about the risk when it comes to managing explainability and things like bias, and a lot of the risks involved in what happens when an employee or a team member makes a mistake or an omission, and you may not be covered. And it has to do with how the team manages that response. I wanted to ask your thoughts on what I'm seeing as a trend in sort of the fifth pillar of vulnerability, right? We have artifacts, source, build, we have our cloud. I'm thinking about developers themselves. And we're human, we make mistakes, right? We can also be exploited. We can also download the wrong file. I wanted to ask a little bit if you could reflect on the growing, I think, fifth pillar, I would call it, of developer security posture.
So I'll jump right in because first of all, developers, you're my people.
Yeah.
That's my background. That's where I started. And that's, really, I think that's a fifth pillar. It's been there for a long time. But that's where I said before, where I was talking about the awareness, right? I mean, because we talked about the human element here, 3 years ago? And it's, it is really crucial that we start to get ahead. I haven't met a developer yet who just is like, the cowboy out there, I want to just grab whatever I want, whenever I want. Developers generally want to do the right things, but when we're not able to educate them early on here's the risks, here's the impact your actions could potentially have, here's your potential pitfalls, I want to help you use this technology, but here's how you do it and avoid those pitfalls. That type of awareness and then building the architectures that go with that to say this is how we're going to do it safely is, I think, how you address that.
I'm really sorry that we can't get more into it. We do need to stop, but we have one more question right there.
So depending on the company, the CISO reporting structure could be different. Could be general counsel, CIO, whomever. Mr. Baker, I think you had mentioned that if you don't have a contract, you should get it in writing. There's an understanding that you're protected. Whom should that be from? Is it your CEO? Is it your board?
So great for the CEO. The HR department would also work. It just has to be binding to the corporation. Frankly, if you aren't sure you can get that, we talked about it earlier. You have the manual for how you're going to handle a lot of these things. Write it in there exactly what the procedures are going to be.
Perfect, thank you.
Thank you
Employment
all.
agreements are enforceable, by the way. Employment agreements
Yeah.
are enforceable. That's why you need a lawyer. Wow.
Thank you all.
We did not talk
Okay, no,
about.
thank you all, please.
We did not talk, but I just want to say, the FBI is not your friend. They're going to show up. They're going to want to work with you, and you should. But they are working for the Justice Department, the same people who indicted a CISO. Just remember.
Kirsten, Stuart, Elisa, thank you very much, everybody.
Thanks, everybody.
And let's remember, we are a community. We do support each other. Reach out. People will help you. And we have these lovely reports out there for you to pursue.